So here we want to do, in this particular open house session, we want to discuss a very vital part of the DEPA model for training, where we want to discuss the protective aspects of it. And we're going to have this discussion with Vibhav, and I am Sunu, engineer who is a iSpirit volunteer who's been working in legal tech for a while. And Vibhav, please introduce yourself, and then we can get into the discussion.
Thank you, Sunu. I'm Vibhav. I'm an IPR lawyer who's also working in AI and data protection. I'm also an iSpirit volunteer. And with Sunu, we're here to unpack the protective aspects of DEPA for you.
So you followed the story of the data protection, the DEPA for training, which derives from DEPA for inference, and it's about the formation of the India stack and the story about the flow of info, the flow of money, flow of people, right? And flow of money and flow of people were already handled. So we are talking about the flow of info. Now we are talking about flow of info in a way in which the model builders and the model data providers can collaborate together to create this very vibrant economy, because we all hear based on the Gen AI and other things how AI models are to be infused into society future. So we need to have models. If you in the previous open house, you already heard Hari and Gaurav discuss at length why we need local data, local models to support, right? So when we are using the local data and local models to support it, India, we all have the DPDP Act, which deals with the privacy aspect. But the question is, what are the other things that are critical to ensure this is safe and is compliant across the world? Because someday all these different systems will pull together, right?
Right.
So we've already seen this graph about the growth that we are trying to see. So now we have to come up with regulations which scale and adapt to the growth. So we don't want to hinder it. The whole idea of regulation is to support and grow this architecture, right? So we have to be intelligent about this thing, and that is what Bo and I are going to probably talk about at length later. The path to value is very important in this case, because if we don't, the end users see applications, they don't see the models like engines, they are driving the cars. Now the path to value is when the applications are used by use for everything, for credit, for healthcare, for travel, and so on, right? Education. Now, at this point, these models have to deliver reliable and safe results to the users. Now, their reliability and safety is contingent upon the data that is in the models, right? And this is the point where Hari and Gaurav have already discussed it in the previous models, and Kapil explained how in the first DEPA open house, how architecture is created in order to ensure from a legal framework, right? Stress being more on techno from those points, how we have created an architecture which allows users to contribute their data safely and for model building to take place in a secure environment. Now we are going to the really to the third stage where these models are going to be used for applications and be distributed in the ecosystem, the society for users to use. And how should we control that, or how should we think about scaling that? So the before I hand it over to Vibhav for his thoughts on the matter, right? I just want to point out that what we are fundamentally going to focus on is data privacy, which we already discussed. What are good models? How do we validate what are good models? And we want to prevent monopolization, ownership of the models, ownership of the markets, etc., by a few entities and potential damages which can come up from that. So, Vibhav, could you just elaborate on these ideas a little, please?
Absolutely. Thank you, Sunu. So I think the first element that we've spoken about is data privacy, right? So in data privacy, as it was highlighted earlier, we have the Digital Personal Data Protection Act now. The law is looking at the collection of personal data, and it has certain obligations for the data fiduciaries and the data fiduciary or the significant data fiduciary when it is taking data from a data principal. There are certain obligations put in that. The key point, as far from a from an AI development perspective in it, is that the Data Protection Act is confined, and the scope of the act is confined within the four corners of the data protection law, and it is only talking about collection use and the mechanism of personal data collection and the obligations that different parties may have. Of course, when we look at uh, good models, in addition to the second thing that you see on this slide, in addition to the data privacy element, good models also have to be free from bias. There are ethical choices that go out in development of these models, which will something that we'll touch upon in later. There are risks that are obviously present in development of AI models when the models are put in the market. One example of risk being of course bias. Other risks that is very recent of AI that one can see is perhaps deep fakes. So the point being there from a legal perspective is that while the data privacy element is perhaps is protected by, in some form, is protected by the Digital Personal Data Protection Act, when we look at AI, we are also looking at outside the privacy realm, and which is more in the broader sense of user harm. So when we're talking about good models, we're not only talking about development of good models, we're also talking about models uh, that mitigate harm to users and harm to society in a way. The third point that we're looking to cover when we talk about no monopolies, right? So the broad idea about no monopolies there is that when we're looking at developing the or further building upon the Indian AI ecosystem, we're talking about greater access, we're talking about more developers, we're talking about spreading the growth of or development of AI models across the sector in a way that it is not concentrated perhaps uh, in a few players perhaps, but the point there being that the monopoly element has a twofold aspect to this, right? One is of course providing access and spreading it across different players. The second element is that uh, while existing players are present, what do we do today in a way that with the market that it is today, how do we provide greater access with the market as it stands today, and how do we modify the existing market so that we have at the inception itself greater players involved in AI development and development of AI models. I think that's the broad overview of both data privacy, good models, and no monopolies. And we'll be fleshing this out when we're talking about how to protect it from a regulatory aspect as we go along. Over back to you, Sunu.
Thank you, Vibha. So with that under our belt, let's go and start discussing the points in a little bit more detail. And at the end of this discussion, what we want you to take away is how do we propose an architecture in the country in order to create a smooth flow from the data principles, the creators of the data, to the data, back to the data principles through the models and through these usage applications, which is safe and secure and so on, right? So this is what we've already discussed, right? And this whole idea, as which we have discussed in the previous open house, it has been implemented on the adepts and the organs principles, which we have already talked about in the previous one. So I'm not going deeply into that, right? But these adept and organ principles are the core of the DEPA architecture. And when we want to build regulatory frameworks around it in order to promote it, right? The citizens who want ChatGPT like experience and other applications, right? And the enterprises want to compete against the monopolization by big tech because these foundational models are practically owned by the big tech. And the data providers who want to collect the data and who want to, let's say, for example, monetize or realize much greater value from the data, but we want to do it under the ADEPT models and organs principles, ADEPT principles and the organs principles. The question is, how do we create a regulatory organization, right? And that's what we are going to discuss. This part, I'll just quickly go through it again. This is just a repeat of how we have created techno-legal framework. And goes back to the work that Kapil and Hari have presented, which is from the data provider through the consent manager, which effectively implements the DPDP Act and so on, purpose limitation, all the way through CCR, which is the confidential clean rooms, which is the technical framework which allows models to be built without any violation of privacy and maintains the privacy standards to a very high level of guarantee, to the training data consumer. And this is the so we take the story begins for taking off from the training data consumer and taking forward. And three things that we want to focus on in terms of the techno-legal aspect of regulation is data privacy, which Hugo has already mentioned in context of the law. Model validation. How do we ensure that these models are good models? And how do we look at monopoly prevention? So we have you can comment further on. Let's look at the data privacy part. I think we're fairly secure on that. But how should we go about implement all of them together? Right? What would be our pathway towards realizing convergence of all of this together?
Right. Now, that's an excellent question, Sunu. I think when we're looking at the convergence of those three elements, we have to really look about how is it if we want to, and how do we want to regulate AI or AI development. And I think there are a couple of big points and rather fundamental points that I think we need to think of. And it's an in, evolving space, but there are a couple of big points that we need to think about at the start. First, of course, is that we're not looking to regulate and to bring all those three elements together. We're not looking to regulate AI technology as a whole. That is fairly broad, unclear, and ambiguous. The way to go about this could be to look at use of AI technology, the specific use cases, the way AI applications are being developed, which AI application is being developed, what it is doing, what and how, who are the users going to interact with it, what is the impact that it may have, right? And the harm that it may create or the impact that it may have, which is very simply put, we're talking about a use case regulation, not a regulation of AI as a whole. And if we understand how this has evolved also uh, globally, even OECD spoke about risk-based frameworks. What we're really talking about as a fundamental starting point is a risk-based classification, and the risk being that I am not looking at AI technology as a whole, but I'm kind of classifying risk, and the risk classification could be contextual, cultural, perhaps what matters in one jurisdiction over another, not like a blank. So the agreement could be that there could be a high risk model, there could be a medium risk or a low risk model, and there is a discussion of risk also in the Indian context, in certain in the fairness standard published by the TEC, the Telecommunication Engineering Center of the Department of Telecommunications. It's not an idea that's completely alien in the Indian context. The broad idea is present. But when we're talking about risk classification, what we're really talking about is identifying which AI application presents a greater risk, which presents perhaps a lesser risk, and which perhaps present a least risk. And from that risk approach, we are able to narrow down, as in when we are bringing all those three elements together, how do we want to bring them together? When it's least risk, what are the elements that we need to combine them? When there's slightly higher risk, let's say medium risk, what kind of mechanisms do we need to have in place? If it is the highest risk, if it's high risk, then what additional mechanisms do we need in the development of these models? So the stitching together of those three elements, data of course is a starting point, but model validation and the other elements are there connected with this risk-based classification. That's the first point. The second point is that we need to look at, when we're talking about AI regulation and bringing these three elements together, we have to be clear whether we want to include generative AI in this aspect or not. Generative AI, of course, any technology is fast moving and it evolves very fast. And of course, regulation is finding its way to create certainty or clarity along with technological development. But it's important for us with this fast pace that perhaps Gen AI has put that 2x, 3x, 4x speed to the development. And we have to be clear when we're looking at regulating AI, are we looking to cover generative AI? If we are covering generative AI, and perhaps we could, because there are certain use cases of Gen AI in the market. That's a call that has to be taken. But assuming that we do cover generative AI, perhaps generative AI could fit within one of the risk classifications. And again, to caution, to go back to the original point, we're not talking about regulating generative AI as a whole. Again, we are breaking down the application of generative AI, what and how generative AI is being used, what risk or what harm it may create, and then tying that back to the original risk framework that we've spoken about. So, Sonu, that's really the starting point about stitching it together. Risk based classification, perhaps keeping Gen AI in the fold. And if we are keeping
Mm,
Gen AI in the fold, then that the use case of that gets fit into any of the risk models.
that is, yeah, thank you. That is very insightful because the end of the day, what we wanted to do was to say that the technology is moving very fast, like you said, and we can see on the horizon many useful applications coming out of the AI models finally, both generative and non-generative. And the whole point about creating the regulatory framework is to give a, a playground for these models to develop and be raised in practice. Technically, we would say internally, we say that we are regulating for AI rather than regulating AI. So we want to work at the point of creating a space where these applications can take flight,
Absolutely.
right? So a
Absolutely.
risk-based classification, which allows the low-risk ones to be freer and the high-risk ones to be more controlled, is probably the most logical way to go about doing that.
Right.
So one of the things we are looking at, there's a little bit technical part, as again the techno part of so we already discussed the techno part of the data privacy in terms of the CCR model. The techno part of the model validation section really refers to the fact that there are mathematical models and more structured ways of analyzing what is a model, and the applications coming from the model is the portal for the model to reach the society, and when the data starts flowing into the society and people start interacting, how is the society as a system going to react? It is a complex system, it is adaptive, and it changes dynamically based on where the data is flowing and what are the possible things that can happen. Then we ask the question of, are there individuals or specific parts of the whole network which can influence it for their personal gain, right? Or can there be damage caused in the society without somebody not realizing it, that potential damage is there? So we are developing a mathematical model in order to address all these questions. There's a technical part of the model verification and validation. And at some point, this would be a standard, but a very how do I put it, a lightweight standard. It's not too difficult to do this to a certain extent. Of course, this is not a 100% guaranteed way of doing it because it is a probabilistic model. But this will be the light standard to which the applications would have to adhere to, right? And the idea is to having this common standard enables multiple players to come, right? Small companies, large companies, everybody will be equal in this model. Now we come to a much more complex part, which again will, I will ask you to discuss at depth because this is far harder to deal with, the notion of monopoly and what it means in this context. So go ahead, please, Vibha.
Sure. So I think I would also want, before I come to monopoly, I do want to
Yeah,
also
yeah,
address one more element, the last part of your previous slide about the
please. Yeah,
unintended consequences, right? When we are speaking
that's
about
okay.
models, on the extreme right, which is models can cause unintended damage to individuals and societies at large when used at scale without understanding the consequences. Now, and I will come to the monopoly part after that. I'll address both together. But
Yeah,
first, on this point, there's an important example that comes out from is in the context of generative AI and copyright law when we're talking about unintended damage to individuals and societies at large, right? Because if we look at the elements of if in very simply put, right, if we look at generative AI and the kind of claims that have been brought in, the kind of claims that have been brought in against generative AI models, some litigations in the US, where the simple claim is that an AI model has ingested in training data certain copyrighted material, and therefore by ingesting copyrighted material, which could just, for a very simple example, let's say ingested text or used text, copyrighted protected text in training a generative AI model. And then when the output was released from the generative AI model, the author of that text looked at it and said, okay, this is copying my style. This generative AI model is obviously taking my style, my way of writing a book. And then there is a claim that has been brought against that AI model, against that developer. Now, the reason I bring that up is only to highlight the complexity that when we are talking about unintended damage, or when we're talking about the repercussions that happen when we are building these models, is some of the risks that are present, right? And copyright is a good example when you're talking about a pro innovation approach, because we have to balance that out with respect to innovation and creation. So when we look at that element, the main point that has to be brought out from this is that copyright law, when you look at existing copyright law, you there is obviously a claim that could be there, that there is a copyright infringement claim from what you have trained and how you've trained it, and my copyright is being violated. There's simultaneously there is the defense of, say, whether that's actually infringement or not, right? Because it could be the fact that it's actually fair use, and it's not actually an infringement in the first place. Simultaneous, so that's one element of damage. And therefore, when we're looking at the development of these models, there's a claim, then there's a defense. One has to look at a mechanisms of being aware of these risks, and therefore what are the solutions that we can find as on date, and perhaps what could we do for the future. When we talk about as on date, right? So as on date, these are gray elements that we have to be aware of, because as on date there is a claim and there is a fair use is the defense element to it. Japan, of course, has gone in a different direction by saying that it's okay to train uh, copyrighted material, and that's all right for training data. But the question of fair use is open in the US. In the UK, also in the EU, for example, the EU AI Act, there's this discussion about disclosure of the content in the model. And therefore, when we're looking at as on date, we're talking about a situation where if you are an AI developer, or perhaps in the DEPA context, if you're a training data provider, you are in a position obtaining the data from the data principal to be aware of which data perhaps uniquely belongs to which individual. And in that scenario, to perhaps have mechanisms to mitigate the risk by perhaps providing a compensation mechanism. There is an example of that happening with one developer abroad, where a person who was providing a data to a AI developer set up a compensation mechanism back with the artists whose images they were using. That's one point about the
So,
damage element that we're trying to highlight. Yes, Sunu, please.
so there's a question here. Yeah, an important question here. In the previous models, we were talking about DEPA for training, and there is the TDP who is collecting the data from the data principles, right?
Right, right,
And the consent artifacts are part of the data collection process.
correct.
Does this discussion imply that the TDP also needs to look at copyright aspects of the data when it is collecting the data from the data principal, and these copyright notices, etc., should be treated as part of the data set?
Yeah, I mean,
Like the model builder, does the model builder need to ask the TDP to say that, hey, I am taking data from you in order to build the model, but you must also give me information about all possible copyright issues associated with data? That level of transparency is required.
absolutely. From my perspective, most definitely, because the this is a gray area. This is a gray area. Situations are, as I mentioned, there is the legal position is still evolving, but from a and we're coming in purely from a risk mitigation perspective. I
Right.
think it's important for to have that clarity. Also because it would and perhaps not only have that clarity, but with that awareness, perhaps build in mechanisms to 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 mitigate that risk, which, as I indicated, one could be that whichever player in the chain is aware of, supposing I took 5 images, and I'm giving an example. We take 5 images, perhaps those 5 images are copyrighted, and I provided that ahead for AI development. There is someone in the chain, perhaps the TDP, training data provider, or perhaps the consent manager who took it from the data principal. Someone in the chain is knows that those 5 images came from whom. And if we don't know that, we have to have a mechanism to track that and keep that somewhere in a way, so that, or perhaps an indemnity from the data principal itself, that none of it is copyrighted protected. But the point is there has to be tracking of, I am, copyright is an example of intellectual property protection, but let's use that as a simple base as how litigation has happened abroad, or claims have been brought in.
Okay.
And copyright elements, they could also be yeah, copyright elements, and therefore we have to have a mechanism where we're able to track that and sort of get a clarity that there are no copyright elements present in the training data element,
Okay.
right? And that's the unintended damage part. And it's a fairly, and it's something that has to be thought of while we're developing this model. The other element that I did want to cover on this, when we were talking, because we're also talking about AI regulation, or we're talking about about the use of these tools. While there might be these claims of AI, using creative work, and some risk being there, and copyright infringement claims being brought, I want to be clear about it not being a doomsday scenario. I think AI at the same time is also an enabler. So when we come back to copyright law, we have to understand that it obviously, if I use an AI tool correctly as a creative person, and and if I have significant human involvement in the prompts that I give, and the manner in which the AI tool is creating an output, or the manner in which I am using AI in my day-to-day work, I can use AI as an enabler. So I'm kind of talking about two sides of the same coin. When I'm developing an AI tool, uh, as a data principle, perhaps I have to be clear and forthcoming in terms of the copyrighted material. Someone down the chain has to be very clear which material is copyright protected. Simultaneously, while I'm providing my data as a data principle, I'm really talking from a common citizen perspective here. While I'm providing my data as a common citizen to perhaps for AI development ahead, I also should not be shy of AI, using AI for my work, because it is obviously, there are mechanisms where the AI could function. For example, when I used to sketch earlier, then I got a camera, and through a camera I could take photos, right? So I had another medium for expressing my creativity. In that same vein, especially with the advent of generative AI, if used smartly with the correct awareness, can also be an enabling tool for the creativity that I, as a creator, want to exhibit. So both these elements
Right.
we need to keep in mind. And now
Okay.
finally, and to coming to your point on monopoly, so these were the gray elements which I wanted to talk about, because this point is important when we're talking about verification and validation, to kind of be
Right.
aware of some of the risks. The monopoly part is, I think, monopoly prevention. Of course, it's a term that plays out, but there's one important element that I want to highlight, a very fundamental element, really not getting into too much legal nuance here. But when we are talking about competition law or prevention of monopoly, right, the law is guarding against abuse of dominance. The law guards against abuse of dominance, not dominance per se. So when we're talking about existing legal mechanisms, we're really talking about a situation where we will check abuse of dominance, and perhaps that, if that may not perhaps be in sync, or the way that we're looking at monopoly prevention, one of the ways that I think this element could be achieved, when again we're coming in from a legal lens, is that what we're really looking at is a greater spread for AI development, right? So which means that we want greater access, we want
Yeah.
more developers on the scene, perhaps we want, and in the mechanisms of the DEPA infrastructure, where we're going and collecting data and creating data sets and developing AI models, in that sense, what we're trying to look is that we're obviously fashioning or designing the way things ought to be, and therefore sort of creating a greater spread through this infrastructure that has been built through iSpirit. But in addition to that, while we are moving towards, say, a broader democratic spread out way of, say, AI development taking place in every nook and corner, right? Like, for example, to draw an analogy from cricket, you have players coming in from each state in the national team. You want AI development coming in from each state of the country, right? From different parts of the country.
Right.
That being the goal, that is, according to me, the articulation of monopoly prevention. And that is perhaps forward looking. And of course, with DEPA, we're probably starting on the ground today itself. But along with that, we also have to utilize the way things are today, which means that if we have certain players out there who have built these models, and they've then no one
Right,
really intends to cause harm. Everyone is doing it from a perspective that furthers benefit, right? We also have
right.
to have mechanisms where we build in and utilize existing AI models and develop
Hmm,
frameworks, perhaps licensing out from them, and use the existing scope as well for through
hmm.
licenses and other mechanisms, so that that existing base model,
Yeah,
as you know, the term foundation model that I believe has been spoken of in the
correct.
EU context, right? We use those
Right.
models and we build upon them. So when we are talking about monopoly prevention, what we're really talking about is spreading or creating dots of AI development on India's map, and kind
Yeah.
of using this mechanism to spread that out by having more dots. If you look at India's,
Hmm,
you imagine India's map in your mind, and each dot represents where AI development is coming from. So you're trying to increase the number of dots on that map.
right, right,
Simultaneously, with the development that has taken place today, you are, through licenses, adding more dots. So you're using what we
right.
have today and using this unique mechanism, building ahead for the future. So both go side by side.
That is a very important aspect about dominance versus abuse of dominance. The whole thing that we are thinking about is we would like to address the question that if there is one single dominant model in an ecosystem, does it damage or cause problems in the ecosystem going forward into the future? But that we can go back to the ecosystem modeling and address it. But like you said, this is what we have today, and that itself serves as a very good platform to build the expansion of AI models, like putting all these dots in everywhere in the map of India. And that's really what we want to achieve, right?
Exactly.
So this is again to go back. We already discussed this that about how we have confidential clean rooms, we have complex adaptive system models. Now the data part you have discussed at length. That is how we need to implement the copyright models and things like that to create open data. So along with TDP, TDC, the DP, and the ability for remuneration compensation to flow back all the way to the DP, we are dealing with an open data system. And at the end of the day, one important thing which I want to ask you, Vibhav, is that how lightweight do you think the legal landscape? Because we know that heavy regulation will work against the growth of an ecosystem. So we want the regulation to be effective but lightweight, right? And a supportive regulation, right? Because we want AI to be supported. So the current regulation, right? We already built it in the DEPA, in the CCR model. We built in electronic contracts, which are like self-enforced contracts. But going forward into the model validation as well as the monopoly prevention and so on, when we create the regulatory agency, the SRO, the self-regulatory organization, I mean, what is it? How would you, from a perspective of coming from the legal side in Indian context, feel about making it light and effective? Yeah.
Right. It's an excellent question, Sunu. Uh, the fundamental, and which is already mentioned here on the slide, is one of the most fundamental starting points to have a lightweight regulation. To break that down, we are looking at pro AI innovation at the threshold. I mean, that's really the fundamental starting point. And to be able to have that, uh, there is obviously requirement of technology and legal elements intersecting in the development or in the fashioning of the regulation, which is why the techno-legal framework kind of fits in well with this approach. And with these two approaches of promoting AI innovation and promoting techno-legal framework, I think one, obviously there's a feedback loop that's required by appreciating the technology, the way it's developing,
Mm,
going back to the element of the identifying which use cases, which applications do you really want law to step in, if you want it to step in at all.
right.
I mean, that has to be the other
Okay.
guiding factor. And then
So that'll be
talk
based on the risk classification.
risk classification, absolutely, the risk classification, and the SRO, the self-regulatory organization element. I think is in a very unique, or perhaps a very important concept in, if you're looking at the larger picture, for perhaps a central point for people who are developing AI models from different, like we just spoke a few minutes back, that if the goal is to put as many dots on the map of India, we also have to appreciate that
Right,
those dots are coming in from different social, cultural, political, language contexts, right? And therefore, there is
right,
a need for certain for the need of certain clarity about where they will go. And of course, the AI
right.
landscape legally is A, developing, B, it is obviously spread out, sectoral in nature. For example, you would have the privacy element that is being taken by the Data Protection Act. The Digital India Act is not out. That's a discussion. So we have, when you're looking at user harm in the information technology space, then we have the IT Act. and
Mm,
and then of course we spoke about copyright, so then we have the relevant IPR laws. So the development of these models is will obviously be governed by the laws that they are, but in a way to
mm,
harmonize this collaboration, perhaps the
right.
SRO could be a model where one could have a situation where you could have a central point, as broad and as simple as that for now, a central
Right.
point for someone developing an AI tool to to collaborate, or to put all their things on their checklist. At the
Mm,
same time, when we are talking about an SRO, we have to go a little deeper in. It's a good idea, it's a good concept, but it has to be looked at with these, what role and what, how would the SRO play out. And as we've spoken about
right.
the exactly, and we've and the point is, we're just getting into that, and the point is that it being a techno legal framework, as the SRO plays out, we have to be cognizant of good feedback loops, so that we do
Mm,
end up creating a central point if we're envisioning in that direction, in a way that does work
wow. Yeah.
practically across, because we have to take in the existing infrastructure of laws while proposing the innovative idea that you've just brought forth.
So, in your mind, an SRO, would it be a single central organization or would there be multiple regional organizations? I mean, in terms of scaling out, because again, we are putting dots in many parts of India with many different cultural structures. So,
Right.
would it make more sense for SRO to be a little bit local or regional, or to be more sensitive and more scalable so it can address the demand? There's a big ecosystem at the end of the day.
I think an SRO will have to be, when we look at an SRO, it'll have to be like it'll have to be the body that helps be the one point for the AI developer, or the
Right.
relevant stakeholder in that chain. And
Okay.
along with, and of course, the developer will also have to have awareness of of the broad existing laws that take place. Because if you're looking at envisioning an SRO is a very useful concept, but it has to take into account the existing framework. And therefore it might be that the SRO could be a central point which says, okay, you have the data protection law, you have the IT Act, you have IP laws.
Right.
Alternatively,
That's right.
that's one way of looking at it. Alternatively, we could have, say, SRO, we're in 2023, let's hypothetically assume that SRO comes in January 2024, hypothetically. Then in that date,
Right.
uh, then there's an SRO, and I'm developing a model, say, on 2nd January 2024. Then on 2nd January 2024, I could be, okay, I'm going today, there is now a body which is in the central body that I must go for my AI development. It'll give me guidance. But before this body
Mm,
came into effect, there were these other laws that I'm aware that I have to be compliant with, or that I have to take care, check with my team. So both approaches work. I mean, I think for the way the
okay.
legal infrastructure is developed, of course, there is obviously going to be some coordination between an SRO and the other parallel uh, elements as well. So to fashion out these nuances will have to be figured out. So the way that, so that, because the goal, I mean the intention behind creating an SRO is to bring in consistency, clarity, a predictability for an AI developer, right? And therefore, when we
Correct.
are fashioning it,
Yeah.
when we are designing it, we have to think through in that design that it represents and
Mm.
brings in that it does achieve its purpose by when we are designing that suppose. That's important. Over to you, Sunu, for your further thoughts on how this would work.
No, I concur with you completely because the whole idea is to create an SRO such a way that it provides a regulate common standard, the common reference point, but the regulations or the standard can be easily met. SROs support of agencies who want to create models which are standardized, right? And it is that role that we are really at such for the SRO. But like you said, there are so many nuances. So there is a certain degree of complexity to building the SRO models and how these interactions will happen. And that is something that we should touch upon because, in the interest of time as well, as to how companies who are actually practically building things these days. No, SRO is not there as yet. It is an idea. We are working on part of it. How do these things dovetail so that though you don't have to be waiting for SROs to develop and for these regulatory framework to be created? And that is actually the message that we should be able to define for the ecosystem to grow, right?
Right.
So I think that SRO will do all the things that you said, right? It'll be able to monitor, it'll be able to measure the after the deployment activity of these things, of the models, whether they are working, right? And if the models are doing bad things or they're bad actors, we will figure out some way of managing them, because there are consequences to pulling a working model out of an ecosystem, right? How do you take a working engine out of a car without damaging the car or stopping the car in dead, right? Things like that. So we have to solve those problems. But SRO, we do have a model around it. The question is, how do we move the ecosystem towards complying with this, right? And we already have the timeline which we discussed about how the in the previous session as well, right? We have a target, like I said, large scale model based ecosystem with multiple products there, right? Now we have to help the companies get that, right? That is the fundamental question that we want to get to. So this is our picture, right, where we have open and regulated data markets, we have verified data models and applications, we reach the world of safe and secure users and societies. This is where I would like to, have your insights into how do model builders, companies, application builders create a framework where they can work with an SRO model.
Right. No, that's again a
Yeah,
very
please
very
go
good
ahead.
question. Very good question, Sunu. No, that's an excellent point, because see, what the question is really asking is that yes, the regulations may take some time. We are figuring out how to build these regulations, but how do I approach it today? I think the one short answer to that is, of
Yeah,
course, that there has to be a willingness to be proactive. And how we will be proactive, I'll just outline that as a suggestion perhaps. But there has to be a willingness to be proactive as the landscape develops, and that's important if you're looking to capitalize on AI development. I'm not sure, I'm not clear whether an wait and watch approach, because absolute clarity in such a fast evolving space is tricky. So a way to go about this is perhaps to look at, of course, you have some guidance given by the Data Protection Act. There is some guidance given in by the IT Act, which speaks about certain harms, and the rules that have come out in 2021, where it speaks about certain harms in social media context and all of that. But those laws cover, the laws are going from the impact that certain use is happening. But if you are looking at a more broader perspective, entities should really be looking at some of their internal structures, and this could be three individuals, it could be committees, but very broadly speaking, one could, keeping the data protection part aside, which is privacy, we can also look at something like different committee structures which take care of different elements of an AI development. For example, we could have something, a committee called the model validation committee, which in perhaps in the DEPA infrastructure, which is something that captures the algorithmic risk, which means the risk from an AI system. There is a committee, or it could be a committee, it could be one individual if it's a small organization with the relevant training and experience, which is capturing the possible risks that are present in an organization. That's the algorithmic risk committee or the model validation committee. The second could be capturing the ethical choices that happen while developing an algorithm. And I want to break down this concept of ethical choices. When we speak about ethical AI, not talking about some fungible abstract concept. It's a very specific point that I'm looking at, independent of how society is looking at the ethics of AI. I'm talking about from an AI developer perspective. When we speak from an AI developer perspective, we're talking about the choices that the team that is developing the AI model has made while developing the tool, because a team is comprised of a finite number of people. They will come from their own
that's right.
lived experiences and moral framework and cultures and values, and there could be some decisions while while training, developing the model, choosing your data set, eliminating the data set, making a call.
Correct.
There will be certain calls that you would take, perhaps consciously, subconsciously, through how you are as an individual and how you are functioning as a team. And therefore there's something called capturing the ethical choices made while developing an AI system. That's called the ethics committee, which I believe is also part of
Right.
the DEPA element. So there's the model validation committee that's there, is capturing algorithmic risk. There is the ethics committee.
Right.
Then we of course have the data protection law, which will now take care of the personal data aspects in that. Perhaps, and
Right.
perhaps from a precautionary perspective, more so like how the gaming platforms have also grown in Indian context, is perhaps the data protection element could look at children's data and perhaps capturing those
Mhm.
specific use cases, going back to the risk approach about how, if there are
Right.
certain use cases that are impacting children, so we could have a committee or an individual taking care of the children data independent of personal data, if that's a call that you're want to take as an organization. And all of these three elements so far are obviously independent of the legal framework. No one's asking you to do this. It's more of a suggestion to get you thinking, if you want to get started, or if you're already working in this space, to restructure yourself in a way that is
Mm.
best protecting your way of being responsible, or doing it in a sense of in a manner that best supports the ecosystem. In addition to that,
Right.
we also have the post marketing element as well, that if we have if we are capturing risks, and supposing if you're not if you've already developed it and it's already out in the
Mm.
market, then perhaps something called adverse incident reporting. Because see, the big point
Okay.
that I'm driving through these committees, whether it be algorithmic risk ethics committee, children's data oversight committee, the data protection officer, and all of them, and perhaps adverse incident reporting, all of them perhaps reporting the the top management. And if we look at actual roles in the Indian context, we have the idea of a data protection officer for a significant data fiduciary that's come out in the data protection law. We also have this concept of a grievance
Right.
officer, but that more so in the context of significant social media intermediaries in the Indian law, not so much in the AI context. But what I'm trying to highlight is that there's this concept in law where a particular individual aren't under current law, or particular body or organization, certain accountability
Mm.
and responsibility law
Right.
has placed on them in existing laws. They may or may not be covering AI, that's a separate issue. But taking a leaf out of that sort of approach and kind of trying to do it voluntarily, there are these suggestions of creating
Mm.
these kind of committees or individuals
That's
responsible and
right.
accountable, so that you can perhaps, as a best practice, so that you can perhaps
Mm.
create your own structure. Because at the end of the day, an AI developer knows best what is it that they are developing, how they intend to use it,
Right.
what data they have used, how they intend, and what impact it will have. And with this awareness
Yeah.
of data protection, IP, algorithmic risk, ethical choices, where the data came from, children's data, if you develop a macro perspective also with your development, you
Mm.
manage to create a overarching framework for yourself, which is
Right.
flexible, adaptable as things develop.
That is, yeah. Thank you, Vibhu. That is actually a very important thing because what we need to identify at this point is a way in which people do not have to wait and watch because the technology is moving too fast. So wait and watch might not be a logical strategy, and they have a way to go forward. And you're saying that there are already some standards in terms of the grievance officer, data protection officer, etc., to extend it into the notion of committees. And it is more like a pact, a voluntary pact, and the companies coming up with best practices so that they will all fit together with the SRO structure at a later point, and they are all aligned, right? They are all fundamentally aligned in their own aims. And the whole idea between SRO is that SRO will also globally align itself with every other standards which is developing out there. So that way, the AI models developed within India by these companies will align with the global standards, right? So you will get kind of this thing. That is an excellent way to proceed instead of waiting for all these regulatory frameworks to develop. So I think we are running out of time. So the whole idea we already discussed the group committees. You already elaborated on it, that how they will be supportive and will scale to meet it, right? So,
Absolutely.
so I think we are nearly at the end of. So what we are really talking about is that how we're going to realize the vision for the economy. We have done the technical research and development, and we are it's still ongoing and things like that. But the best practices and the legal framework from the regulatory perspective that we've just outlined in this discussion is probably key to bringing it all together. And you can go to it allows you to go into launch into the market and adopt it at scale, right? And I think Vibhav, I will ask you for your last thoughts on this, and we'll end. Thank
No, no, absolutely. I think we have to understand that AI development has to take into account how things are and how things can would be ahead, and how things would be, perhaps like you said, we as things shape up, we must do the best internally as an organization to be flexible and adaptable by designing the correct structures. We should be aware, or at the development
right,
stage, at the different elements that we're interacting with. Data, IP are two of them. There could be cybersecurity elements as well, data breach elements as well. So
right.
it has to be the final part, the final, really final thought from my end is that if you really want to develop an AI model and you want to be part of the AI ecosystem, just get started, design yourself, and just
Mm,
go. Try waiting and watching and
yeah.
waiting for the perfect solution will not work. I think being imperfect and moving ahead with what you have is the way to go forward.
Okay. Thank you, Vibha. Thank you, Antara. I think
Thank you.
that is the message that we want to take out, that we have outlined the framework under which this moving forward is possible, and therefore we should just simply move forward. Right. Yeah.
Thank you. Thank you.
Thank you.